You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Welcome to We Get Work live from Workplace Horizons 2025. In the podcast studio with us this afternoon, Laura Pearson-Scheinberg, principal in Jackson Lewis's San Francisco office, and Dan Shudroff, principal in Jackson Lewis's New York City office, and both top thought leaders in the labor law space. Welcome to We Get Work this afternoon. Thanks for joining us.
Thank you for having us.
Thank you for having us, yes.
Dan, so if you could tell us a little bit about your practice, which I just mentioned happened to include labor law, and what you're hearing from clients these days.
Thank you, Alicia. I focus primarily on traditional labor law with both unionized and non-unionized clients, but I assist clients from a whole wide range of issues, including advice and counsel from state and federal standpoints, employment litigation, both in federal and state courts, as well as administrative agencies, and anything that falls in between. And I do a lot of work with employers within New York City and New York State, but also around the country as well. And the multi-state employers look to us, and as a firm, we have a great team to provide guidance.
And Laura, you are the co-leader of our labor and preventative practice groups, as well as our retail industry group. So, a lot of issues, a lot of employers. Tell us a little bit about your practice and the issues that you're seeing in your space.
Yeah, so I always go by Laura, the labor lawyer, easy to remember. And I truly do all issues labor. I spend a lot of my time on labor strategy, both in the union and non-union space. We really deal with the entire life cycle of the union process. But in my role as I deal with the clients across the country. I actually have a presence also in Baltimore. So I have that bi-coastal experience, and really, especially now with the change in the administration and sort of a difference in cooling off. So it's not cooling off in California at all. But I've heard sort of in the East, the Southeast in particular, unionization issues have cooled off a bit. We're certainly not experiencing that in Cali for sure.
In fact, the title of your presentation this afternoon was all about worker activism and how to prepare for the expected surge. So, Dan, why don't you tell us a little bit about what you covered in the presentation and, what are the issues people can still expect?
So Laura and I were fortunate to be joined by Chairman of the National Labor Relations Board, Marvin Kaplan, who spoke about issues going on at the National Labor Relations Board, including with respect to issues involving protected concerted activity, workplace rules, and union organizing. And I believe that as a panel, we were able to kind of explain to our audience about all the things that could be happening in the next few months or even year at the National Labor Relations Board.
And it's a really weird time, right? Because there's no quorum at the National Labor Relations Board. So kind of everything in Washington is sort of frozen. But in the regions, we are seeing cases processing. And in fact, where cases have been dormant, there is some movement. And so we're seeing more settlements because of, some relaxed approach on what they're willing to accept at the board, because they were sort of backing off some of the, apology letter and other, extra damages that they don't typically seek. But now we're seeing a loosening of that. And so we are seeing some activity in the regions. But as Chairman Kaplan talked about, without a quorum, they're kind of left with not much to do. And so he's been spending his time, sort of one of his favorite things to do is to draft opinions. So he's been spending his time drafting those potential opinions of those cases to swing back for the team that might come in, because his appointment ends in August.
So we talked a lot here in the podcast studio with other speakers about how much things have changed and how much uncertainty there is. And apparently that's also true in the labor space. What can we tell our clients? What can we tell our listeners? What are some of the key takeaways that you might have discussed or that Chairman Kaplan might have provided in his time as guest speaker on your panel?
So I think what Laura said is absolutely right, that right now without the quorum in place, there's not a lot of change to be expected immediately. That being said, clients can read the tea leaves from past cases that were issued during the first Trump administration to see where the law might go. But a lot of these issues are still on hold right now, and it all comes down to a risk tolerance from an employer's perspective as to whether or not that particular employer wants to take the risk that, based on the current law as it stands, whether or not an allegation filed in an unfair labor practice charge could come before an administrative law judge before the law changes potentially back to a favorable employer stance. And that's an open question that none of us can really answer. So it really comes down to a risk tolerance and how much people or how much employers are willing to take on from a gamble standpoint as to whether or not their case would be decided before the law might shift back.
Very tenuous position for our clients and something difficult that you have to help them get through as we move forward.
And we're really looking at whether you want to go the patience route. Do we want to wait until the pendulum swings, and how long? And, as Dan talked about, this risk tolerance, but also like the severity of the issue. Is this, what is important? What are all the outcomes, pros and cons of compliance, or predicting and reading those tea leaves as to where you hope it's going, and then maybe you're that case.
Well, I guess unless you get an advance copy of one of those drafts of Chairman Kaplan's opinions, we all have to play the waiting game a little bit, I guess. Laura, Dan, thank you so much for participating here at Workplace Horizons and in the podcast studio this afternoon, and enjoy the rest of the conference.
Thank you for your time.
Thank you for having us.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.